The CDCR is committed to providing a workplace that protects the civil rights of its employees. Consistent with this commitment, CDCR strives to provide equal employment opportunity for all employees and applicants for employment, as well as a harassment-free work environment. The knowledge, skills, and willingness to ensure discrimination, retaliation, and sexual harassment do not occur in the workplace. During this course, you will complete the following learning objectives. Identify behaviors that violate the CDCR Zero Tolerance Equal Employment Opportunity Policy. Identify the definitions of protected groups as basis for filing a discrimination complaint. Identify the theories of discrimination. Identify the internal and external options available for filing a complaint of discrimination. Identify roles and responsibilities pertaining to equal employment opportunity and sexual harassment prevention. Information regarding CDCR's Zero Tolerance EEO policy and the EEO complaint process can be obtained from local EEO coordinators, EEO counselors, the Office of Internal Affairs Civil Rights Operations, or CDCR intranet and internet websites. You will identify behaviors that violate the CDCR Zero Tolerance EEO policy and/or may violate the laws protecting employees from discrimination or harassment. 1. The CDCR Equal Employment Opportunity Policy, and 2. The EEO Sexual Harassment Laws. CDCR is required by law to provide a workplace free from harassment, discrimination, and retaliation. When an EEO concern is brought to the CDCR's attention, the CDCR is required to take immediate and appropriate action to stop the offending behavior. Violations of EEO laws can cost the CDCR and employees millions of dollars in court-ordered compensatory and punitive damages, in addition to litigation costs.
On June 15, 2020, by a vote of 6-3, the U.S. Federal Supreme Court said, Title VII of the Civil Rights Act of 1964, which makes it illegal for employers to discriminate because of a person's sex, among other factors, also covers sexual orientation and transgender status. It upheld rulings from lower courts that said sexual orientation discrimination was a form of sex discrimination.
You will identify the definitions of the protected groups as basis for filing a discrimination complaint. 1. Prima facie, EEO elements, basis, harm, nexus. 2. Theories of discrimination. To determine if a complaint meets prima facie standard under the CDCR EEO policy, the following elements must be alleged, declared by the complainant. The complainant must identify a protected group identified under statute. The complainant must allege a harm has occurred, and the complainant must identify a causal connection, nexus, between the protected class and the alleged harm. Prima facie is established when the complainant alleges he or she has been harmed, i.e., denied promotion, harassed, terminated, etc., as a result of being a member of a protected group. In addition, a causal connection appears to exist between the complainant's protected group and the alleged harm. Age, 40 or older, medical condition, ancestry, national origin, color, political affiliation, disability, physical or mental, race, genetic information, religion, sex, gender, gender identity, gender expression, sexual orientation, marital status, and veteran status, military service. A qualifying harm is an employment action and has an adverse impact on a complainant's job situation. This can include, but is not limited to, failure to appoint, failure to promote, job duty change, transfer, failure to accommodate based upon disability, pregnancy, or religious beliefs, practices, or observances absent and undue hardship, denial of leave, change in working conditions, demotion, and termination. To establish a causal connection for an act of discrimination, the complainant must demonstrate that a harm occurred because of his or her protected status. You will identify the theories of discrimination. Discrimination is the failure to treat an individual in the same way as others because of a protected basis. In order for a complaint to meet the jurisdictional requirements for an EEO complaint, an employee must allege he or she is part of a protected class or is perceived to be part of a protected class and must provide sufficient information to indicate a factor in the actions taken was due to his or her membership in the protected class. Theories of discrimination link an alleged action to a protected basis. Theories of discrimination include disparate treatment, disparate impact, harassment, retaliation, reasonable accommodation, and religious accommodation. Disparate treatment is defined as an allegation by a complainant that he or she was treated differently because of his or her membership in, perception of, or association with a protected class. Disparate treatment occurs when a protected class of persons is treated differently from other employees or when they are evaluated by different standards. Examples of disparate treatment include, but are not limited to, a supervisor has several employees who continually make discriminatory jokes and use crude, vulgar language while at work. The supervisor only takes adverse action against employees who have accents. A supervisor only approves training, mentoring, and provides leadership opportunities for employees of a specific racial group. An employer only hires married employees as opposed to single employees. A supervisor demonstrates harsh mistreatment and dislike for an employee because of his or her religion. Harassment is an act committed by a person that makes another person feel uncomfortable, offended, intimidated, or oppressed based on his or her protected class. It consists of exposure to behaviors or conduct that creates an intimidating, hostile, or offensive working environment or unreasonably interferes with the individual's work performance. Workplace harassment is unlawful and violates the FEHA and Title VII and CDCR policy. Examples of harassment include, but are not limited to, verbal, epithets, derogatory comments, or slurs. A coworker continually makes derogatory or offensive statements to a fellow coworker because of his or her sexual orientation. Visual, derogatory posters, written items, cartoons, or drawings of a person's protected bases. Physical, assault, impeding, blocking, or physical interference with normal work or movement. An employee pokes their finger into a coworker's chest because they choose to practice a specific religion. Posting, sending, or uploading, downloading messages with discriminatory or retaliatory content in any form via electronic mail, the intranet, internet websites, cell phone, office mail, or personal mail. Making harassing telephone calls to a coworker or sending harassing correspondence to an individual by means including, but not limited to, public or private mail, inter-office mail, facsimile, computer email, or text messaging.
Gender identity. Gender identity means each person's internal understanding of their gender, or the perception of a person's gender identity, which may include male, female, a combination of male and female, neither male nor female, a gender different from the person's sex assigned at birth, or transgender. Example of harassment based on gender identity. Treating an employee differently, or making disparaging remarks to an employee after finding out about the employee's gender identity, or planned transition.
Pronouns. It is important to use the correct pronouns a person prefers, out of respect, consideration, and support. If someone hasn't made it clear which pronouns they prefer, it is always okay to ask. Typically, the most respectful way to ask this question is to avoid, "Are you a he or a she?" and to instead ask, "What pronouns do you use?" or, "What are your preferred pronouns?" Current state of affairs for LGBTQA+. 53% of LGBTQ employees report experiencing or witnessing anti-LGBTQ comments by coworkers. 47% of LGBTQ employees believe being out at work could hurt their career. 80% of transgender employees report experiencing workplace harassment. 68% of LGBTQ employees believe their employers can do more to support LGBTQ and ally employees at work.
Sexual orientation. Sexual orientation means heterosexuality, homosexuality, and bisexuality. Example of harassment based on sexual orientation. Insulting an employee, making disparaging remarks, threatening him, or subjecting him to offensive gestures due to his sexual orientation.
California Government Code Section 12940, Subdivision K requires an entity to take all reasonable steps to prevent harassment from occurring. If an employer has failed to take such preventative measures, that employer can be held liable for the harassment. A victim may be entitled to monetary damages even though no employment opportunity has been denied and there is no actual loss of pay or benefits. All employers have a legal obligation to prevent sexual harassment. Employers must take all reasonable steps to prevent discrimination and harassment from occurring. Employers must help ensure a workplace free from sexual harassment by posting in the workplace a poster made available by the Department of Fair Employment and Housing. Employers must help ensure a workplace free from sexual harassment by distributing to employees information on sexual harassment. Information provided must include the following: the illegality of sexual harassment, the definition of sexual harassment under state and federal laws, a description of sexual harassment utilizing examples, the internal complaint process of the employer available to the employee, the legal remedies and complaint process available through the Department of Fair Employment and Housing and the U.S. Equal Employment Opportunity Commission. The protection against retaliation for opposing the practices prohibited by law or for filing a complaint with or otherwise participating in investigative activities conducted by the CDCR or other state or federal agencies. Sexual harassment is defined under state and federal laws and by this policy as unsolicited and unwelcome sexual advances, requests for sexual favors, and other verbal, physical, or visual conduct of a sexual nature that interferes with work performances by creating an intimidating, hostile, or offensive work environment. Such conduct constitutes sexual harassment in violation of this policy when submission to the conduct or communication is made either explicitly or implicitly a term or condition of employment. Submission to or rejection of the conduct or communication is used as a basis for employment or service decisions affecting the individual. Such conduct or communication has the potential to negatively affect an individual's work performance and or create an intimidating, hostile, or offensive work environment. The type of prohibited discriminatory or harassing behavior which may be found to constitute a violation of CDCR's EEO policy includes, but is not limited to, demanding sexual favors in exchange for employment benefits or as a term or condition of employment, whether explicitly or implicitly. Engaging in any unwanted physical contact, including touching, leering, making sexual gestures, impeding or blocking movements, pinching, grabbing, patting, intentionally brushing up against another individual in a sexual manner, rape, or sexual assault. Engaging in retaliation after a negative response to sexual advances, using sexually derogatory terms or telling sexual jokes and/or stories. Displaying objects, cartoons, pictures, or posters of a derogatory or sexual nature, posting, sending, or uploading, downloading sexual or demeaning materials in any form via electronic mail, the internet websites, cell phones, inter-office mail, or public or private mail. Following or stalking an employee, making harassing telephone calls of a sexual nature to a coworker, or sending sexually harassing correspondence to an individual by any means, including but not limited to the use of public or private mail, inter-office mail, facsimile, electronic mail, or text messaging. An employee is fired or denied a job or an employment benefit because he or she refused to grant sexual favors or because he or she complained about harassment. Retaliation for complaining about harassment is illegal, even if it cannot be demonstrated that the harassment actually occurred. An employee quits because he or she can no longer tolerate an offensive work environment, referred to as a constructive discharge harassment case. If it is proven that a reasonable person under like conditions would resign to escape the harassment, the employer may be held responsible for the resignation as if the employee had been discharged. An employee is exposed to an offensive work environment, exposure to various kinds of behavior, or to unwanted sexual advances alone may constitute harassment. Sexual harassment does not need to occur between two people of the opposite sex. In fact, many cases involve same-sex harassment. Two types of sexual harassment, quid pro quo, and hostile work environment. Quid pro quo, Latin term meaning this for that, harassment is the act of offering employment benefits in exchange for sexual favors. This situation may also involve third parties who are treated less favorably because others have agreed to sexual advances. Quid pro quo harassment usually happens between a supervisor and a subordinate employee. Quid pro quo harassment occurs when employment decisions or expectations, hiring, promotions, salary increases, shift or work assistance, etc., are based on an employee's submission to or rejection of sexual advances. Quid pro quo harassment involves tangible actions that adversely affect either the conditions of work or progress. The invitation to enter into the barter for exchange is unlawful. It is not necessary that the harasser follow through with the offer or threat in order for the behavior to violate state and federal law. A hostile work environment occurs when there is a discriminatory conduct or behavior in the workplace that is unwelcome and offensive to an employee or a group of employees based on a protected class. The conduct, whether verbal or physical in nature, must be severe or pervasive. A single incident usually does not constitute a hostile work environment. However, a single incident of harassment may constitute a hostile work environment if the harassment includes either physical violence or a threat of physical violence. Regarding severity, the pattern of behavior must cause a beyond reasonable disruption, such as when an employee becomes disturbed because of intimidation or fear of loss of employment. The objective severity of the harassment is judged from the perspective of a reasonable person in the complainant's position, considering all of the circumstances, and is guided by common sense and sensitivity to social context. Accordingly, the courts consider how a reasonable person who is comparable to the complainant would perceive the harassing acts.
EEO retaliation is an adverse employment action taken against an individual due to his or her protected activity, opposition to a discriminatory practice, or participation in the discrimination complaint process or other EEO-related proceedings. EEO retaliation includes taking adverse action, discharging, expelling, or otherwise discriminating against any person because that person has opposed practices forbidden under the Title VII of the Civil Rights Act of 1964 or the California Fair Employment and Housing Act, FEHA, or because the person has filed an EEO complaint, testified or assisted in any EEO complaint proceedings. Examples of EEO retaliation include, but are not limited to, an employee files a sexual harassment complaint against a supervisor and receives a job change as a result of filing the complaint. An employee is called a snitch and tattletale and is ostracized after filing a complaint against a coworker. An employee is ostracized, criticized, and bullied after he or she has participated as a witness in a discrimination investigation. Reasonable accommodation is any modification or adjustment to a job or the work environment or in the way things are customarily done that enable an individual with a disability or pregnancy-related conditions to enjoy equal employment opportunity. Reasonable accommodations ensure equal opportunity in the job application, examination, and hiring processes. Reasonable accommodations will enable a qualified applicant or employee with a disability to participate in the application, examination process, or to perform the essential functions of their job or any other job for which they meet minimum qualifications. Employee Health and Wellness Return to Work Coordinator oversees all medical personnel actions taken by the department statewide to include all institutions, parole offices, and juvenile facilities. Medical personnel actions include, but are not limited to, medical transfers, medical demotions, disability retirement, and medical termination for all industrial and non-industrial employee medical issues. Employee Health and Wellness encourages employees, supervisors, and managers to contact them for assistance in working through medical personnel actions. Participation in the interactive process is the mutual responsibility of each employee requesting an accommodation and the department. The interactive process related to a reasonable accommodation for a disability or pregnancy is administered by Employee Health and Wellness via the Return to Work Coordinator. The interactive process related to religious accommodations is administered at the local level through the EEO Coordinator. Participation in the interactive process is required in disability, pregnancy, including childbirth and lactation, and religious accommodation requests. A reasonable accommodation can be requested as a result of a disability, pregnancy, and/or pregnancy-related conditions. Religious accommodations can be requested to accommodate sincerely held religious beliefs, observances, or practices. The Fair Employment Housing Act, FEHA, defines a person with a disability as someone who has any mental or psychological disorder or condition, such as intellectual disability, organic brain syndrome, emotional or mental illness, or specific learning disabilities that limits a major life activity, a mental or psychological disorder or condition that limits a major life activity or makes the achievement of the major life activity difficult, any physiological disease, disorder, condition, cosmetic disfigurement, or anatomical loss that affects one or more body systems, any other health impairment that requires special education or related services. Under the FEHA, the threshold is very low. The Americans with Disabilities Act, ADA, a federal statute, defines a person with a disability as one who has a physical or mental impairment that substantially limits one or more major life activities, has a record of having an impairment, is perceived as having an impairment. The essential functions of the job still need to be met. Religious discrimination occurs when employment benefits have been denied in whole or in part because of an applicant's or employee's religious beliefs, observances, and/or practices, or lack of those, or the employer fails to reasonably accommodate the applicant's or employee's religious beliefs, observances, and/or practices, despite being aware of the need for reasonable accommodation. Requests for religious accommodation should be referred to the EEO coordinator. Civil Rights Operations Headquarters will provide technical assistance in the requests for religious accommodation. The hiring authority will make the final decision on request for religious accommodations. A request for a religious accommodation does not have to be granted if it creates an undue hardship on the employer's business. An undue hardship is an action requiring significant difficulty or expense. An undue hardship may exist if the requested accommodation creates safety or security risks, conflicts with a memorandum of understanding, conflicts with state and federal laws, or results in a waiver of an essential function of a position. The essential functions of the job still have to be met.
For purposes of this section, abusive conduct means conduct of an employer or employee in the workplace with malice that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests. Abusive conduct may include repeated infliction of verbal abuse, such as the use of derogatory remarks, insults, and epithets, verbal or physical conduct that a reasonable person would find threatening, intimidating, or humiliating, or the gratuitous sabotage or undermining a person's work performance. A single act shall not constitute abusive conduct unless especially severe and egregious. Abusive conduct may include repeated infliction of verbal abuse, such as the use of derogatory remarks, insults, and epithets, verbal or physical conduct that a reasonable person would find threatening, intimidating, or humiliating, or the gratuitous sabotage or undermining a person's work performance. A single act shall not constitute abusive conduct unless especially severe and egregious. Abusive conduct where the policy applies, the work environment such as any location, either permanent or temporary, where the employer and or employees perform work for the employer, including buildings and the surrounding perimeters, parking lots, field locations, travel between workplace locations, and after-hour situations that affect the workplace, such as an employer-sponsored event or informal gatherings of the employees. Any location on a business trip, such as a hotel or in a car. You will identify the internal and external options available for filing a complaint of discrimination. 1. Discrimination complaint process. 2. Remedies for employees. 3. Immediate and appropriate action. All complaints received by the department are taken seriously. The CDCR provides 2 methods for filing a complaint: the local intervention process and directly with the Office of Internal Affairs Civil Rights Operations. An employee is not required to confront the person or persons engaged in the conduct believed to be in violation of the department policy at any time before or after the filing of a complaint. No employee is required to contact his or her direct supervisor to report conduct believed to be in violation of the policy. Local intervention process. The purpose of the local intervention process, LIP, is to resolve a complaint of discrimination, harassment, or retaliation at the lowest level. If an employee believes an EEO policy violation has occurred, he or she may file a complaint verbally or in writing using the discrimination complaint form CDCR 693. Any discrimination complaint or any reported issue that may violate the EEO policy received from any employee, job applicant, volunteer, unpaid intern, contractor, or vendor must be forwarded to the EEO coordinator within 24 hours. If the allegations are egregious or include sexual harassment allegations, the complainant should be aware that complete confidentiality cannot be assured because of the department's legal obligation to take immediate and appropriate action. Confidentiality. All EEO complaints are confidential and should not be discussed with anyone unless the person has a legitimate business need to know. The department will maintain confidentiality to the extent possible. Ultimately, confidentiality is not guaranteed. Filing a complaint. An employee may choose to bypass the LIP and file a discrimination complaint directly with CRO via a CDCR 693, email, telephone, CRO hotline 1-800-272-1408, or memorandum. When CRO receives a complaint, each allegation is evaluated to determine if the allegation warrants an investigation or other action to be taken. A CRO analyst will schedule and conduct an intake interview with the complainant if additional or clarifying information is needed. Failure to report. Every allegation of employee misconduct within CDCR shall be promptly reported, objectively reviewed, and investigated when appropriate. Each employee, regardless of classification or rank, shall report misconduct or any unethical or illegal activity in a timely manner. Failure to report employee misconduct or any unethical or illegal activity in an investigation or allegation inquiry shall be grounds for corrective action, disciplinary action, or both, per DOM Chapter 3, Article 14. Failure to report. Employees shall make full, complete, and truthful statements. Failure or refusal to make statements or making false statements during internal affairs investigations may result in disciplinary action. Employees shall not take any action which would interfere with, delay, distort, or unduly influence any official investigation conducted by the department or any other government agency. Any employee who knowingly gives false evidence, withholds evidence, or interferes in any way during such an investigation, or requests or encourages another to do so, may be subject to disciplinary action. Failure to report. In addition, an employee's failure to report harassment may reduce the damages that may be recovered, taking into account an employer's anti-harassment policy and procedures and its past record of acting on harassment complaints. Damages may be reduced if the employee unreasonably failed to report the harassment to the employer sooner. External complaints. All employees, volunteers, unpaid interns, retired annuitants, vendors, contractors, and applicants may elect to file a discrimination complaint with the following external compliance agencies: U.S. Equal Employment Opportunity Commission, EEOC, California Department of Fair Employment and Housing, DFEH. Employees are not required to exhaust the Internal Administrative Procedure, EEO Coordinator, LIP, or OIA CRO before filing a formal discrimination complaint with the EEOC and/or DFEH. Third-party EEO complaints. Any employee may submit a verbal or written complaint to an EEO coordinator, EEO counselor, manager, or supervisor describing an inappropriate conversation, conduct, or written visual posting that may violate the CDCR Zero Tolerance EEO policy. Remedies for employees. A complainant is entitled to make whole remedies if a preponderance of the evidence establishes that the complainant was subjected to unlawful sexual harassment which caused him or her to suffer harm. He or she is entitled to recuperate damages for emotional distress and physical harm suffered as a result of the respondent's conduct, in addition to any compensation for employment opportunities lost, out-of-pocket expenses incurred, etc. Remedies for employees include local resolution, departmental remedies, EEOC and DFEH remedies, court-ordered remedies.
Knowledge review. The purpose of this activity is to reinforce what you have learned from this training. Mark true if the statement is a violation of EEO Sexual Harassment Policy, false if it is not a violation. Failing to engage in the interactive process or denying or failing to provide a reasonable accommodation for a disability or for religious reasons, absent an undue hardship. True or false? Take a moment to answer the question to yourself. The correct answer is true. Mark true if the statement is correct, false if it is incorrect. Only physical conduct of a sexual nature constitutes sexual harassment. True or false? Take a moment to answer the question to yourself. The correct answer is false. Select the word that correctly matches the definition below. To establish a causal connection for an act of discrimination, the complainant must demonstrate that a harm occurred because of their protected status. Nexus: harm, discrimination complaint, sexual harassment. Take a moment to answer the question to yourself. The correct answer is nexus. Complete the sentence below by selecting the missing words. The purpose of the Local Intervention Process, LIP, is to resolve an EEO complaint at the blank lowest level, limited level, fastest level, headquarters level. Take a moment to answer the question to yourself. The correct answer is lowest level. Complete the sentence below by selecting the missing words. Failure by manager, supervisor to adhere to the responsibilities outlined in the CDCR EEO policy, may result in corrective or disciplinary action, up to and including, blank, from the department. Dismissal, suspension, guidance, training. Take a moment to answer the question to yourself. The correct answer is dismissal. Mark true if the statement is a violation of EEO Sexual Harassment Policy, false if it is not a violation. Making employment decisions, on the basis of an individual's ability to perform duties, required for a particular job. True, or false. Take a moment to answer the question to yourself. The correct answer is false. Mark true if the statement is correct. False if it is incorrect. Sexual, or racial epithets, derogatory comments, or slurs at work are acceptable. True, or false. Take a moment to answer the question to yourself. The correct answer is false. Select the word that correctly matches the definition below. An issue that has an adverse impact on a complainant's job situation. Retaliation. Harm. Harassment. Hostile work environment. Take a moment to answer the question to yourself. The correct answer is harm. Complete the sentence below by selecting the missing words. If an employee wishes to file an EEO complaint, he, she, may use the blank, or file directly with the Office of Civil Rights. Local Referral Program, LRP. Local Intervention Process, LIP. Limited Review Process, LRP. Local Level Process, LLP. Take a moment to answer the question to yourself. The correct answer is Local Intervention Process, LIP. Complete the sentence below by selecting the missing words. Any employee, who is found to have violated the CDCR Equal Employment Opportunity, EEO, policy, may be held, blank, for their conduct. Partially responsible. In contempt. Reasonably responsible. Reasonably liable. Take a moment to answer the question to yourself. The correct answer is personally liable. On the following screen, you will receive a blank certificate for this training. Please pause the video on the bottom left of your screen, video player, once you see the certificate. Then select the Print Screen button on your keyboard. Paste the image into Paint. Here you may crop and print the certificate, to turn in. End of training. This concludes your training. Thanks for watching and participating.